Yes, sir. Yes, sir.
ಸುಮಾರು 3 ವರ್ಷ ವಯಸ್ಸಾಗಿರುತ್ತೆ. ಸುಮಾರು 4 ವರ್ಷಗಳಿಂದ ಚಂದ್ರಶೇಖರ್ ಅವರ ಅತ್ತೆ ಮಕ್ಕಳನ್ನು ಇಬ್ಬರು ಸೇರಿ ವರದಕ್ಷಿಣೆ ಕಿರುಕುಳ ಈ ವಿಷಯ ಅವರ ಹೇಳುತ್ತಿದ್ದರು. ಆಂಜಿನಪ್ಪ ನಾನು ನಮ್ಮ ಅಣ್ಣನಾದ ಹೊಸಕೋಟೆಯಲ್ಲಿ ಹೇಳಿರುವ ಹೇಳ್ಬೋದ ಎಂದು ಅತ್ತೆ ಹೇಳುತ್ತಿದ್ದರು. ಈ ದಿನ 17/11/2019 ರಾತ್ರಿ ಸುಮಾರು 8:30 ಸತ್ತಿದ್ದಾರೆ ಎಂದು ನಮಗೆ ತಿಳಿಸಿದರು. ನಾವು ಆಂಜಿನಪ್ಪ ಮತ್ತು ಎಂದು ಹೆಣ್ಣುಗೋಪಾಲ್ ಮತ್ತು ಸರೋಜನ್ನು ಸುಮಾರು ರಾತ್ರಿ 9:30 ಗಂಟೆಗೆ ಒಂದು ನೋಡಲಾಗಿ ಮಂಚದ ಮೇಲೆ ಮಲಗಿಸಿದರು. ವಿಚಾರ ಹೇಳಿದಾಗ ಇವರು ಚಂದ್ರಶೇಖರ್ ಮತ್ತು ನನ್ನ ಮಗಳು ಮನೆ ದೇವಸ್ಥಾನಗಳು ಕೇತ ಭೈರವೇಶ್ವರ ದೇವಸ್ಥಾನಕ್ಕೆ ಸುಮಾರು 3 ಗಂಟೆಗೆ ಹೋಗಿದ್ದಾರೆ ಮತ್ತು ಇಂದ್ರಿಗೆ ಸುಮಾರು 6:30 ಗಂಟೆಗೆ ಕರೆದು ಹೋಗಿದ್ದಾರೆ. ಗಂಡ ನನಗೆ ಕಾಲು ಎಂದು ಹೇಳಿ ಆಮೇಲೆ ತರುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ಡೋರ್ನಲ್ಲಿ ನೋಡಿದಾಗ ಫ್ಯಾಮಿಲಿ ಮಾಡಿಕೊಂಡಿದ್ದರು. ವರದಕ್ಷಿಣೆ ಕಿರುಗಳಿಂದ ಚಂದ್ರಶೇಖರ್ ಇಬ್ಬರು ಸೇರಿ ಕಿರುಕುಳ ನೀಡಿದ ನಟ ಎಂಬುವರು ಈ ರೀತಿ ಮಾಡಿಕೊಂಡಿರಬಹುದು. ಸಾವಿನ ನಿಖರವಾದ ಕಾರಣವನ್ನು ತನಿಖೆಯನ್ನು ತೆಗೆಯಬೇಕು ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇವೆ. ಈ ದೂರು ತನ್ನ ಅಣ್ಣನ ಮಗನಾದ ಆನಂದನ ಕೈಗೆ ಬೆಳೆಸಿರುತ್ತದೆ.
Yes, sir.
And thereafter will be charged with the frame of offense and the principal under 488 and 304B and 3 of the Dowry Provision Act. And also 4 of the Dowry Provision Act which is not accused person. During the trial of the PW1, that's been examined. ಚಾಸ ಒಂದು ನನ್ನ ಗಂಟ ನನ್ನ ಮೂರನೇ ಮಗಳು ನನಗೆ ಆರೋಪಿ ಕಳಿಸಿದ್ರು. ಒಂದನೇ ಆರೋಪಿ ಲತಂಗ ಗಂಟ, ಎರಡನೇ ಆರೋಪಿ ಒಂದನೇ ಆರೋಪಿ ದಿನಾಂಕ 21/6/2010 ಲತಾಳ ಮದುವೆ ಒಂದನೇ ಆರೋಪಿಯೊಂದಿಗೆ ಬಾಲೇಪುರದ ಚಟ್ಟದಲ್ಲಿ ಎರಡು ಮದುವೆ ಮುಗಿಸಿ ಕೊಡಬೇಕೆಂದು ಹೇಳಿದರು. ನಾವು ನಮ್ಮ ಕೈಲಾದಷ್ಟು ಮದುವೆ ಕೊಡಬೇಕೆಂದು ಕೇಳುತ್ತೇವೆ ಎಂದು ಹೇಳಿದರು. ನಾವು ಹುಡುಗರಿಗೆ ಬಟ್ಟೆ ಬರೆಯಾಗಿ 1 ಲಕ್ಷ ನಗದನ್ನು ಕೊಟ್ಟಿದ್ದೇವೆ. ಮಗಳಿಗೆ ಒಂದು ಲಾಂಗ್ ಚೈನ್, ನೆಕ್ಲೆಸ್, ಮುತ್ತಿನ ಉಡುಗೆ, ಜುಮುಕಿ, ಹ್ಯಾಂಗಿಂಗ್ಸ್, ರೆಡ್ ಸ್ಟೋನ್ ಒಂದು ಹ್ಯಾಂಗಿಂಗ್ಸ್, ಒಂದು ಜೊತೆ ಹಾಕಿ, 2 ಜೊತೆ ಫ್ಯಾನ್ಸಿ ಓಲೆ, 2 ಉಂಗುರಗಳು, ತಾಳಿ ಚೈನ್ಗೆ ಹಾಕುವ ಕಾಸುಗಳು, 2 ಜೊತೆ ಬೆಳ್ಳಿಯ ಕಾಲುಗಳನ್ನು ಕೊಟ್ಟಿದ್ದೇವೆ. ಉಡುಗರಿ ಮತ್ತು ಚೈನ್ 1 ಉಂಗುರ ಕೊಟ್ಟಿದ್ದೇವೆ. ಕಾಲು ಚೈನ್ ಹೊರತಾಗಿ ಉಳಿದ ಆಭರಣಗಳು ಚಿನ್ನದ ಆಭರಣಗಳು ಮದುವೆ ಆಭರಣಗಳ ಮೇಲೆ ಸುಮಾರು 5 ಲಕ್ಷಕ್ಕಿಂತ ಹೆಚ್ಚಾಗುತ್ತದೆ. ಮದುವೆ ದಿನ ಒಳಗೆ ಆಭರಣ ಕೊಟ್ಟಿದ್ದು ನಮ್ಮ ಮಗಳಿಗೆ ಮನೆಯಿಂದ ಹೋಗುವಾಗ ಮದುವೆ ನಾವು ಮಾಡಿದ್ದೇವೆ. ಮದುವೆ ಆದ ನಂತರ ನಮ್ಮ ಮಗಳು ಮದುವೆ ಆದ ಸುಮಾರು 1 ವರ್ಷ ನನ್ನ ಮಗಳ ಮತ್ತು ಅಳಿಯನ ಮಧ್ಯೆ ಸಂಬಂಧ ಚೆನ್ನಾಗಿ ಇತ್ತು. ಒಂದನೇ ಆರೋಪಿ ಮದುವೆಯಿಂದ ಮೊದಲು ಸಿಮೆಂಟ್ ಮತ್ತು ಕಬ್ಬಿಣದ ವ್ಯವಹಾರ ಮಾಡುವ ಹಾರ್ಡ್ವೇರ್ ಅಂಗಡಿ ಇಟ್ಕೊಂಡಿದ್ದರು. ಮದುವೆಯಾದ ನಂತರ ಅವರ ವ್ಯವಹಾರದಲ್ಲಿ ನಷ್ಟವಾಯಿತು. ಒಂದನೇ ಆರೋಪಿ ಸ್ನೇಹಿತರೊಂದಿಗೆ ಸೇರಿ ಮದ್ಯಪಾನ ಮಾಡುವ ಮನೆಯಲ್ಲಿ ನಮ್ಮ ತಾಯಿ ಕೇಳುತ್ತಿದ್ದರು. ಯಾವಾಗಲೂ ಎರಡನೇ ಆರೋಗ್ಯ ಮಾತು ಕೇಳಿ ಲಾಟವಾಳೊಂದಿಗೆ ಜಗಳ ಮಾಡುತ್ತಿದ್ದರು. ಎರಡನೇ ಆರೋಗ್ಯ ಜಗಳ ಆರಂಭಿಸುತ್ತಿದ್ದರು ಮತ್ತು ಅಸಹ್ಯವಾಗಿ ಕಲಿಯುತ್ತಿದ್ದರು. ಅವರು ಆರಂಭಿಸಿದ ಜಗಳಗಳನ್ನು ಒಂದನೇ ಆರೋಗ್ಯ ಮುಂದುವರಿಸುತ್ತಿದ್ದರು. ಆರೋಗ್ಯವನ್ನು ನನ್ನ ಮಗಳಿಗೆ ನೀನು ಬಂದ ನಂತರವೇ ನಮಗೆ ನಷ್ಟವಾಗಿದೆ. ನೀನು ದರಿದ್ರದವರು, ನೀನು ತಂದ ಒಡವೆಯನ್ನು ಸಾಲುವುದಿಲ್ಲ, ಇನ್ನು ಒಡವೆಯನ್ನು ತೆಗೆದುಕೊಂಡು ಬಾ ಎಂದು ಹೇಳುತ್ತಿದ್ದೆ. ನನ್ನ ಮಗಳಿಗೆ ನಮ್ಮ ಮನೆತನದ ಬಗ್ಗೆ ಹಾಗೂ ನಮ್ಮ ಪರಿಸ್ಥಿತಿಯ ಬಗ್ಗೆ ಹೇಳಿ ಅಪವಾಸ್ಯ ಮಾಡುತ್ತಿದ್ದರು. ಎರಡನೇ ಆರೋಗ್ಯ ಈ ರೀತಿ ಹೆಚ್ಚಾಗಿ ಬೆಳೆಯುತ್ತಿದ್ದರು. ಆರಂಭದಲ್ಲಿ ನನ್ನ ಮಗಳು ಮಾನ ಮರ್ಯಾದೆಯ ಬಗ್ಗೆ ಹೆದರಿ ಸುಮ್ಮನೆ ಇದ್ದರು. ನಾನು ಸಹ ಮಾನ ಮರ್ಯಾದೆಗೆ ಹಂಚಿ ಸುಮ್ಮನೆ ಇದ್ದರು. ದಿನಾಂಕ 8/11/2014 ಮಕ್ಕಳ ಮದುವೆಗೆ ನನ್ನ ಮಗಳು ಲತಾ ಬಂದಿದ್ದರು. ಆ ಸಮಯದಲ್ಲಿ ಬಂದಾಗ ಲತಾ ನನಗೆ ತುಂಬಾ ತೊಂದರೆ ಕೊಡುತ್ತಿದ್ದಾರೆ, ತಡೆದುಕೊಳ್ಳಲು ಆಗುತ್ತಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ದಾರೆ. ಮದುವೆಗೆ ಮನೆಗೆ ಬಂದವರೆಲ್ಲರೂ ಯಾಕೋ ಅದು ಸರಿಯಾಗಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ದಾರೆ. ಎರಡನೇ ಆರೋಗ್ಯ ನನ್ನ ಮಗಳಿಗೆ ತಲೆಗೆ ಪಟಾಕುತ್ತಿದ್ದಾರೆ. ಮುಂದೆರಡು ಸಲ ನಾನು ಆರೋಗ್ಯಕರ ಮನೆಗೆ ಹೋಗಿ ಈ ವಿಷಯದ ಬಗ್ಗೆ ಕೇಳಿದೆ. ಆಗ ಎರಡನೇ ಆರೋಗ್ಯ ನನಗೆ ಕೈ ಮುಗಿದು ನನಗೆ ಇರುವುದು ಒಬ್ಬ ಸೊಸೆ, ನಾನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಳ್ಳುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದಾರೆ. ಎರಡನೇ ಆರೋಗ್ಯ ನನ್ನ ಮಗಳಿಗೆ ನಿಮ್ಮ ಕೊಲೆ ಮಾಡಿದಾಗ ನಾನು ಬದುಕಿಕೊಳ್ಳಬಲ್ಲೆ ಎಂದು ನನ್ನ ಮಗಳು ಹೇಳಿದ್ದಾರೆ. ದಿನಾಂಕ 8/11/2014 ಮದುವೆಗಾಗಿ ಇತರ ಹಳ್ಳಿಗೆ ಬಂದು ನಾವು ಹೇಳಿದವರಿಗೆ ನನ್ನ ಗಂಡನ ಮನೆ ಹೋದರು. ಮದುವೆಗೆ ಮಾಡುವ ಮೊದಲು ಎರಡನೇ ಆರೋಗ್ಯ ನನ್ನ ಮಗಳಿಗೆ ನನಗೆ ಸಾಕಷ್ಟು ತಿರುಗಾಕೊಂಡಿದ್ದೇವೆ. ಈಗ ನಿನ್ನ ಮೇಲೆ ನನಗೆ ಕಾರಣ ಬಂದಿದೆ, ಇನ್ನು ತೊಂದರೆ ಕೊಡುವುದಿಲ್ಲ, ನೀವು ಹೋಗಲಿ ಯಾರೇ ಬರಲಿ ಎಂದು ಹೇಳಿದ್ದಾರೆ. 9/11/2014 ನನ್ನ ಮಗಳು ನನ್ನ ಮನೆಯಿಂದ ಆರೋಗ್ಯದ ಮನೆಗೆ ಹೋಗುವಾಗ ಇನ್ನೊಂದು ವಾರ ನನ್ನ ಜೀವನ ನಾನೇ ಹೇಳಿದೆ. ಇದರ ಮೇಲಿನಿಂದ ನನ್ನ ಗಂಡನ ಮನೆಗೆ ಹೋದ ನಂತರ ನಾನು ಒಂದು ಬಾರಿ ಅವಳಿಗೆ ಫೋನ್ ಮಾಡಿದೆ. ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಗಳು ನನ್ನೊಂದಿಗೆ ಸರಿಯಾಗಿ ಮಾತನಾಡುತ್ತಿಲ್ಲ. ಆ ನಂತರ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಒಂದೆರಡು ಮದುವೆಗಳಿದ್ದು ನಾವು ಮದುವೆ ಕಾರ್ಯದಲ್ಲಿ ತೊಡಗಿಕೊಂಡಿದ್ದೇವೆ. ದಿನಾಂಕ 15/11/2014 ರಾತ್ರಿ 8 ಗಂಟೆ ಎರಡನೇ ನನಗೆ ಫೋನ್, ನಿಮ್ಮ ಮಗಳು ಏನೇನು ಮಾತನಾಡಿಕೊಂಡಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಹೇಳಿದ್ದಾರೆ. ನನ್ನ ಗಂಡನಿಗೂ ಸಹ ಆ ವಿಷಯವನ್ನು ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ದಾರೆ. ವಿಷಯ ತಿಳಿದು ರಾತ್ರಿ ಸುಮಾರು 9 ನಾವು ಬಂದಾಗ ಅವಳು ಅಷ್ಟು ಗೊತ್ತಿಲ್ಲದೆ ದೊಡ್ಡಲಾಗಿದೆ. ಅವಳ ಶರೀರ ಮತ್ತು ಸ್ಥಿತಿಯ ಮೇಲೆ ಯಾವುದೇ ಗುರುತುಗಳು ಇರಲಿಲ್ಲ. ನನಗೆ ಅವಳ ಸಾವಿನ ಬಗ್ಗೆ ಅನುಮಾನ ಇದೆ. ಅವಳು ಏನು ಮಾಡಿಕೊಂಡಂತೆ ನನಗೆ ಅನಿಸಲಿಲ್ಲ. ನನ್ನನ್ನು ತಹಸೀಲ್ದಾರರು ಮತ್ತು ಪೊಲೀಸರು ಈ ಬಗ್ಗೆ ಕೇಳಿದ್ದಾರೆ. ನನ್ನ ಮಗಳ ಶವವನ್ನು ಪರೀಕ್ಷೆ ಮಾಡಿದ ನಂತರ ದೇವನಲ್ಲಿ ಅವಳ ಶವವನ್ನು ಮಾಡಿದೆ. ನನ್ನ ಮಗಳ ಸಾವಿಗೆ ಆರೋಗ್ಯ ಕರೆ ನನ್ನ ಮಗಳಿಗೆ ಹೊಟ್ಟೆ ನೋವು ಯಾವುದು ಇಲ್ಲದಿರಲಿಲ್ಲ. ಹಾಗೂ ಅವಳು ಆ ಕಾರಣಕ್ಕೆ ಏನು ಮಾಡಿಕೊಂಡು ಆರೋಗ್ಯದ ತಿಳ್ಕೊಳ್ಳದಿದ್ದರೆ ಮಾಡಲು ಅವಳು ಏನು ಮಾಡಿಕೊಂಡಿದ್ದಾಳೆ. ಅವನ ಹೆಸರು ರಕ್ಷಿತ. ನನ್ನ ಮಗಳು ಮದುವೆ ಮುಕ್ತವಾಗುತ್ತಿದ್ದಲ್ಲಿ ಆ ತಲೆ ಬಯಸ್ತಾರೆ. ಈಗ ನನಗೆ ತೋರಿಸಿದ ಫೋಟೋ ನನ್ನ ಮಗಳು ಮತ್ತು ಅಳಿಯನದ್ದು. ಅದಕ್ಕೆ ನೀಪಿ 1 ಕೂಡಿಸಲಾಗಿದೆ. ನನ್ನ ಮಗಳ ಮದುವೆ ಹನುಮಂತನ ನೀಪಿ 2 ಎಂದು ಕೂಡಿಸಲಾಗಿದೆ. ನನ್ನ ಮಗಳ ಶರೀರದ ಮೇಲೆ ಒಂದು ಮಾನದ
Sir, one thing I want some clarification. Charge sheet has been laid by the IO against the accused 498A relating to physical as well as mental harassment, otherwise to say cruelty extended by her husband and also her mother-in-law. That is the first charge. The second charges for offences 304B of IPC. That is death, it would occur within a span of 7 years from the date of her marriage. The third one is Section 3 of the Dowry Prohibition Act. Then even Section 4 of the DP Act is also. Even Section 306 read with 34 of Indian Penal Code is also framing of a charge. But in the body of the judgment, it is an acquittal judgment. In the fourth it consisting only 4 sentences. Assistant Commissioner of Police, Devanahalli Subdivision, he has laid the charge sheet against the accused 498A, 304B, read with 34 of Indian Penal Code 1860, and Section 3 and 4 of the Dowry Prohibition Act. All right. It is a domain vested with the trial court. To framing of the charge, it is based upon the materials for which collected by the IO. but 306 also framing of a charge. But acquittal judgment render, even section 498A of IPC or even the acquittal judgment 3 and 4 of the Dowry Prohibition Act, it is in the operative portions of the order, found not guilty of accused number 1 and 2, 3 and 4 of the Dowry Prohibition Act. That is, acting under section 235, 1 and 2 shall be held acquittal, 3 and 4 of the Dowry Prohibition Act. Then found guilty of 498A and 306, read with 34 of IPC. Then acting under section 235, class 2, that is again 498A and 306, read with 34 of Indian Penal Code. It is a conviction against accused number 1 and 2. Accused number 1 is an husband of the deceased. Accused number 2 is the mother-in-law of the deceased. And she is no other than the mother of the accused number 1. But 304B of IPC, within a span of 7 years from the date of her marriage, even though the Assistant Commissioner of Police, Devanalli Subdivision, was laid the charge sheet, even framing of a charge 304B also. But why it has not found place in the operative portions of the impugned order? It is only in para number 36 in the impugned judgment. Instead of 304B, in para number 36, it is indicates lesser the punishment of 306 instead of 304B, then sentences held. It is a sentencing policy, need not framing up a charge also. There was a judgment rendered by the Karnataka High Court also, very long back. There is no dispute about that. Then the trial court arrival of a sentencing policy in that stage, instead of 304B, the conviction held as under section 306 of IPC. But the point for consideration, even point for determination, even framing of a charge, it is 306. Point for determination, it is point number 2, 304B. In point number 2, 304B, framing of a charge, then are whether evidence led by prosecution proves that on the above said date, place and time accused abetment Srimati Latha, the commitment of suicide and thereby committed an offence punishable under section 306. How the trial courts are switch over their mind to in an oscillation? The mind, it must be very pragmatic. The mind, it must be very positive. The mind of a trial court, it must be definite. In case no case of 304B, then reduce into 306, it is some guidelines. It is the domain of the trial court. There is no dispute. But framing of a charge, it is also an important stage. You want to definite about the framing of a charge of 306, you should bring to the notice of the accused 304B or 306. If the prosecution are going to prove, it means to say, it is nothing but as a give an indication to the prosecution and in the 304B will there 306 guarantee conviction ಕೊಡ್ತೀವಿ ಅಂತ. Three not 4B, it is a definite charge. 304B, it is a definite charge sheet laid by the IO against the accused. In case no proving the guilt against the accused, then alternative 306. It is also domain vested with the trial court. But this domain, it is not vested with the prosecution. The prosecution domain only to hear before charge or argument before charge. At that particular stage, the prosecution is, it ought to have say, submitting, sir, it is a safer side, 306 of IPC is also, that charge would be framed. But here is no charge of 306. But determination of an issues, then it is an extraordinary thoughts of the trial judge. It is someone to, I don't say that, prejudice. It is someone to prejudice. Even section 211 of the Code of Criminal Procedure, contents of charge. It is in chapter 17. Contents of charge 1, 2, 3, 4, 5, 6, 7. These are all the contents. Then 212, particulars as to time, place, and person. It is also a mandatory provision. Place of an offense, time of an offense, the person who is committing an offense. That is 212. 213, manner of committing an offense must be stated. Whether the manner of committing an offense means the role of an accused. One accused holding a hands, another accused holding a legs, another accused assisting to the body of a person to whatever the modes, their thoughts, we do not express. That is 213. Then 214, words in charge taken in sense of law, under which offense is punishable. 214. Punishable under section 306, punishable under section 304B, punishable under section 498A, punishable under section 3 and 4 of the Dowry Prohibition Act. This is section 214. 215, effects of errors. In case any errors during the stage of framing of a charge, then the recourse of law as under section 215. Because the fact should not mislead neither to the court, nor to the defense counsel, nor to the prosecution. In case deletion and addition, omission and commission. 216, courts may alter charge. Altering a charge, it is also an important stage in the criminal justice delivery system. At any stage of the proceedings, the trial court can alter the charge. The trial court can addition of a charge. Even the prosecution domain is also vested with making an application or making such kind of a submission. And equally, the role vested with the defense counsel also. In case, this is 216. 217, recall of witnesses when charge altered. In case any alteration of a charge, or in case any addition of a charge, then the domain vested with the trial court immediately to recalling of the witnesses. Otherwise, the prosecution or the defense counsel would submit to adopt the earlier evidence also. That is their submission. Then 219, three offenses committing within a span of a year, it may be charged together. Normally 457 and 380. And then misappropriation cases within a span of 12 months. Then clubbing of a charge. Then 220, trial of more than one offense. Trial of more than one offense also, certain extent, it is in a peculiar facts and circumstances to avoid to interpol the charges. Then trial of more than one offences in a one stretch. Then again, 221, where it is doubtful what offence has been committed. When there is a doubt has been arise in the mind of a court, then the court has to go and apply its mind as under section 221. Even 222, when offences proved included in offences charged, then it is a domain vested with the court. Then 223, what persons may be charged jointly. Then 224, withdrawal of remaining charges on conviction on one of several charges. That is one more similar charge, that is a double jeopardy. Then totally 211 to 224, it is chapter 17 relating to charge. Here is 304B, it is a main charge. 306, it is a lesser punishment charge. That 304B, it is a dowry debt within a span of 7 years from the date of her marriage. But 306, abetment to commitment of suicide. Abetment of commitment of suicide, it is relating to section 107. Definition. Even the definition, it should be completed. The ingredients should be completed only to arrival of 306. Even 304B, it is a dowry death. Dowry death, it is the mode of a harassment. But 306, it is self-suicide. Then self-killing. 304B, subject to harassment and last or breath. 306, suicide. Self, side killing. How to define it? The charges, even determination for point, it is in at a cursory glance of the impugn judgment rendered by the trial judge. Then it is amount to whether it is fit into 304B or fit into 306. In case 306, total ingredients 306 are altogether different. 304B's ingredients are altogether different of an offense of 306. 306 only. In 306, there is no dowry harassment. Yes, correct. Supreme Court judgment is there. Even Karnataka High Court judgment is also there. 306, abetment of suicide. If any person commits suicide, whoever abets the commission of such suicide, how to define 304B? 304B specifically stated dowry death. Dowry death concept is altogether different as a concept of 306. In case 306 are going to be convicted by the trial court, then 3 and 4 of the Dowry Prohibition Act, it is automatically diluted.
cruelty, cause of such a cruelty, the driver commits suicide. 498A cruelty. So that is critical. Really, cruelty which driver commits suicide. That is the attempt. It made them the cruelty, without being the cruelty. He completes 498 was wrong. Dowry not for people. Dowry over the 206 only 498A. It the cruelty to such an extent that it will drive a woman to commit suicide. Abetment. That is only 498 system.
304B, it is relating to the Dowry Prohibition Act 3 and 4. I have to link it, sir. Then 306 and 498A, you have to link it, sir. But broader views think madre now. But 3 and 4 DP Act conviction padbekare necessarily to prove the case in respect of 304B. Or 498A and 3 and 4 Dowry Prohibition. 498A, it is physical as well as mental harassment relating to then even conviction 498A of IPC and 306 of IPC. But in explanation note, in 498A, class D, harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. What is demand? Whether a dowry demand? It is no dowry demand. But law presume. Even 498A in explanation, even conviction held by the trial court, very cautiously to give conviction. Any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause any grave injury or danger to life, limb or health, whether mental or physical, of the woman, or there is a word or. The word or, it is a conjunct of A and B. The word or used, it is a conjoint. It is a conjoint word in a grammatically It is a conjunction. Where there is a, according to this, B is there. Where there is a B, there is A is also there. We must be understanding the enactment who is prepared. We must go through the concept of A and B together. Then what is 498A? Otherwise, it is very difficult. Because punishment clause, it is in 498A. But explanation note, A and B read together. Then only the trial court has to proceed to held conviction. It is extendable to 3 years. Otherwise, no. We do not, shall be split into what is 498A and 498B. 498A, the conjoint word use are. That means to say we must have read together what is A, what is B, then punishment. A is concerned. What is the punishment? Actual punishment of 498A in explanation A.
Commit suicide of 306 times.
498A explanation A की punishment is.
Cruelty and they have stated what is the cruelty, meaning explanation.
498A explanation B and what is the punishment? ಎರಡಕ್ಕೂ punishment B ಅಂತಾನೆ. A ingredients ತಗೊಂಡ್ರೆ whether mental cruelty or physical cruelty. We do not able to assess what is mental cruelty. There is no degree for assessment of physical. In case physical cruelty, some extent only injury. It is a visible injury. Then in B, harassment of woman where such harassment is with a view to coercing her. That is to say, A, explanation A and explanation B shall be read together. Then the definition or ingredients 498A we may able to understand.
They have to prove that the conduct was like this. And the demand was not for dowry, but for some other thing, not related to marriage. Then it will not come under dowry provision. If it is related to demand, is related to marriage, it will come under dowry.
Suppose the bride complexion, it is not a beauty complexion. Then it is a mental harassment. Suppose she is not able to prepare the delicious food. Then it is 498A. 498A explanation A. Sir, ಇದನ್ನ ಅಷ್ಟು ಸುಲಭವಾಗಿ ಅರ್ಥ ಮಾಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ ಸರ್. No, because of my parents, because of my kith and kin, because of my friend circle, I am no other go to accept you as my partner. But you are not a good complexion lady ಅಂತಂದ್ರೆ harassment ಸ್ಟಾರ್ಟ್ ಆಯ್ತು. ಹೆಂಗೆ ಅದನ್ನ ನೀವು 498 explanation A and B ನೇ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ತೀರಾ? There is no yardstick. ನೀವು ಕನ್ವಿಕ್ಷನ್ಗೆ 498A and 306 ಕೊಟ್ರಲ್ಲ, ಹೆಂಗ್ ಬಂದ್ರಿ? 498A either explanation A or explanation B, you are liable to be conviction ಅಂದ್ಬಿಟ್ರೆ ಮುಗ್ದೋಯ್ತು. ನೀವು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ 498 explanation A ಅನ್ಬೇಕಾದ್ರೆ must be careful.
Subjected her to cruelty means 498.
Seeking some enhancement of punishment instead of 306.
And acquittal will not, other than seeking your acquittal of your first mention or being of our being and acquittal.
304B. Lesser punishment it is awarded.
Yes, lesser punishment.
The problem is 306 is commitment of suicide. It is up to 10 years. Hello, sir.
Oh.
Up to 10 years. But 304B of IPC, life. Minimum 7 years or life imprisonment. For 304B relating to the provision of 3 and 4 of the DP Act. In case 3 and 4 of the DP Act, it is diluting. When it is diluting, ended in acquittal. Then naturally 304B it is go out. But 306, it is arrival for conviction. Then alteration of charge or addition of charge or suit the purpose. ಗಂಡನಿಗೆ ಶಿಕ್ಷೆ ಕೊಡಬೇಕನ್ನೋ ದೃಷ್ಟಿಯಿಂದನೇ 306 ಬಂದ್ರ ನೀವು ಟ್ರಯಲ್ ಜಡ್ಜು. ಈಗ ರಕ್ಷಿತ್ ಅಂತ ಒಂದು 3 years ಬಾಯ್ ಇದೆ. ನೀವು 306 498A ಕನ್ವಿಕ್ಷನ್ ಕೊಡಿ ಬೇಡ ಅಂತಲ್ಲ. But what is the stigma? What will be the stigma attached to that Rakshit? How to remove the stigma of that boy? Because in case his father was convicted due to the death of his mother, how to remove all of that stigma attached to that boy? Sir, to answer to my queries, even now, conviction held against accused number 1. But the deceased Latha, who given birth to a child who is aged about 3 years. His name is Rakshit. Now the conviction, it is not to the accused, number 1. It is a conviction to that Rakshit. So harmonious relationship, it should be maintained in between the in-laws and the deceased. Then in-laws, in case that boy, 3 years boy, Rakshit, who is in care and custody of whom? Either the grandparents of his mother or grandparents of his father. Okay, sir. High Court and Supreme Court, ಯಾವುದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬಿಟ್ಬಿಡೋದು. ನೀವು ಬರೀರಿ ಹೆಂಗ್ ಬರೀಬೇಕು ನೋಡೋಣ ಮುಂದೆ ಏನ್ ಮಾಡ್ಬೇಕು. ಎಕ್ಸ್ಪ್ಲನೇಷನ್ 1 ತಗೊಂಡ್ರೆ 498A1 ನಲ್ಲಿ that is thumb crossing prior to her death, frequent quarrel, frequently something it was happened in a family affair. Then frequently there shall be some that bride in case would went to the level of depression. Then subject to the quarrel in between the wife and husband relating to that coercing, whether she will take any treatment in the hospital or she was filed any complaint prior to her death, even earlier incidents in case. Then explanation 1, injury, mental cruelty, then mental harassment. In case her husband used to beat her, then physical harassment. Otherwise, no explanation. Explanation A, injury. Explanation A, mental injury. Explanation A, physical injury. Explanation B, led that woman to commitment of suicide by not fulfilling their demand, either property or landed property or liquid property or property in terms of any household item. ಇಷ್ಟನ್ನೇ ಪಾರ್ಲಿಮೆಂಟೇರಿಯನ್ ಲಾನಲ್ಲಿ ಬರೆಯೋದಿಲ್ಲ, ನಾವು ಅದನ್ನ ಇಂಪೋರ್ಟ್ ಮಾಡ್ಕೋಬೇಕು ಮೈಂಡ್ಗೆ. ಅದೇ ಸರ್,
ಊಟ ಮಾಡಕ್ ಅಡಿಗೆ ಮಾಡಕ್ ಇಲ್ಲ. ಡಿಮಾಂಡ್ ಈಸ್ ನಾಟ್ ರಿಲೇಟಿಂಗ್ ಟು ಡೌರಿ ಲಾಸ್ ಆಫ್ ಊಟ ಅಡಿಗೆ ಮಾಡಕ್ ಹೋದ್ರು ಅವಾಗಲ್ಲಿ ಅಡಿಗೆ ಸ್ಪ್ರೇ ಮಾಡಕ್ ಹೋದ್ರು ಕೇಳ್ಕೊಳ್ಳ ಡೌರಿ ಡಿಮಾಂಡ್ ಇಲ್ಲ.
ಬಿಕಾಸ್ ಹಿ ಇಸ್ ಎ ಹಿಲ್ಲ ಕುಮನ್. ನಿನ್ ಕಾಲ್ಗುಣ ಸರಿ ಇಲ್ಲ, ನಿನ್ ಕೈಗುಣ ಸರಿ ಇಲ್ಲ, ನಿನ್ ಕಾಲಿಟ್ಟು ಬೆಳಗ್ಗೆನಲ್ಲಿ ನನ್ನ ಮನೆ ಆಸ್ತಿ ಎಲ್ಲ ಹೋಯ್ತು.
ಅಡಿಗೆ ಮಾಡಕ್ ಹೋಗ್ಲಿಲ್ಲ. But there is no harassment or ill treatment regarding any demand of dowry related to marriage. Then there is no either demand or any harassment. Dowry question is there. It itself shows that you only proponent it and did not fix it. Cruelty is only to asking her that the not auspicious because they sustained loss after she came. So they want some money and she is not able to prepare food properly. These are nothing related with the dowry. Government did not forbid or dowry is yes.
Shall we take this matter heard in part, sir?
Disconnect.
All right, note one. Learned SCGP for state. In criminal appeal number 1429 of 2016, whereby total judgment in SC number 15007 of 2015, dated 15th of March 2016. A total judgment relating to an offence of 3 and 4 of the Dowry Prohibition Act, and the same has been challenged under this appeal. Whereas in criminal appeal number 1430 of 2016, and the state has referred this appeal by challenging the impugned judgment in SC number 15007 of 2015, dated 15th of March 2016, relating to convicting the accused for the offences punishable under section 498 capital letter A and 306 read with 34 of Indian Penal Code 1860. But in this appeal, seeking for intervention of the punishment awarded by the trial court are found to be inadequacy. Next. Insofar as criminal appeal number 613 of 2016, conviction held by the trial court in respect of A1 and A2 of a judgment rendered by the trial court in S number 15007 of 2015, dated 15th day of March 2016, relating to an offence punishable under section 490 and 306, read with 34 of IPC, has been challenged. But it is an appeal preferred by the convicted accused number 1 and 2. In this matter, SAGP for state Rahul Rai K is appearing before the court physically and also representing the connected appeals. Learned Counsel S. Senkrappa for R1 and R2 in criminal appeal number 1429 of 2016. And so also representing the respondent of the state in criminal appeal number in criminal appeal 1430 2016, yes, Senkrappa representing who? ಇಲ್ಲ
1430 ನೋಡಿ
representing the accused number 1 and 2
ಹಾಕಿದಾರ ಅಂತ
representing the accused number 1 and 2, they arranged as a respondent in criminal appeal number 1430 of 2016, who is on record. So also he being a counsel in a connected case of criminal appeal number 613 of 2016 in respect of A1 and A2, and whereby appeal is preferred by the accused by challenging the conviction held against them for the offences punishable under section 498 and 306, read with 34 of IPC. Full point. Next paragraph. Learned Counsel Vikyat.
Vikyat B.
That's correct, sir. That is 1429. Note of this. But there are 3 appeals.
Vikyat B.
Learned Counsel Vikyat B for R1 and R2 be arranged as accused respectively in this appeal is appearing through video conferencing and representing the counsel as Senkrappa, who is on record. The learned counsel seeking some sort of accommodation on the grounds that one of the counsel on the grounds that some inconvenience caused to the counsel to proceed in this matter for address their arguments. This is a submission made by the learned counsel is placed on record. Next paragraph. Whereas the appeals of the year 2016 and more so the respondent 1 and 2 be arranged as accused 1 and 2 in S number 15007 of 2015, and whereby rendering an acquittal of the offences under section 3 and 4 of the Dowry Prohibition Act, and so also rendering a conviction in respect of an offence under section 498A, 306, read with 34 of Indian Penal Code 1860. However, under this appeal, respectively challenging the acquittal judgment of the offences, and so also conviction held against the accused in respect of the offences which are incorporated in the operative forces of the Impugn judgment rendered by the trial court in SC number 15007 of 2015. Whereas the appeal of their 2016 therefore heard arguments in part of the learned SCGP for state respectively in these appeals. Next paragraph. Whereas keeping in view the submission made by the learned counsel for the respondent 1 and 2 / accused respectively, it is deemed appropriate that this matter be listed on next week in the usual course to address their arguments. Therefore, it is held as heard arguments in part. Consequently, list it next week for further arguments. Yes, sir. Yes, Kumar Badiya.